I had a very interesting scenario the other week. A woman came into my office. She's in her early mid-20s right now. And she came to us in all a panic because of her age. She had appeared on her mother's immigration petition when she was a teenager. That's when they filed the case. And because it had been so many years since the case was filed, now she's over 21, somebody told her she could no longer be included in her mother's case. And that's what she wanted to know from us. Was there any truth to that? And was there any hope that she could still be included in the mother's petition? So sometimes I have to give people bad news, but I was really happy to give her good news that there is a program and a law called CSPA that was passed by Congress in 2002. And CSPA stands for Child Status Protection Act. And essentially, that act was created to alleviate this exact problem. That because there are such long delays in the processing times for many of the immigration petitions, especially the brother-sister category, the F4 category in the family petitions, many people felt it was unfair that if a mom or a dad had kids that were teenagers or younger when the papers were filed, and they would have been included in the ultimate green card appointment interview, that because of the immigration delays and the visa bulletin and the priority dates, et cetera, that they would be kicked out of the case because they turned 21 and they aged out, which is the term for becoming 21 and being pushed off of a case. So Congress created this program called Child Status Protection Act, and they created a new definition of child for immigration purposes. And for example, in this case, where we're talking about a family, we use a formula in order to determine the immigration age of this individual. So if a case was filed at a certain date, that's called the filing date or the priority date, and then it was approved 6 years later, 8 years later, believe it or not, sometimes it does take that long, especially in the F4 brother-sister category. So you've got these two dates. And if you subtract the amount of time that it took between filing and approval, in this case, let's say 5 years, that amount of time can be subtracted from the individual, the beneficiary's biological age. So this woman who's 23 now, if it took 6 years for their case to be approved, we're able to subtract 6 years from 23, and that makes her 17 for immigration purposes. I know it sounds really crazy, but believe it or not, that's what a good lawyer does. They find this, I wouldn't even call it a loophole, this legality in the law, which applies to certain situations and helps people like this woman be eligible for a benefit, a major benefit, being included in a green card case with her mother when the time comes for the interview. So if you are a parent in a situation like this and you have children that were under 21 when you filed and are over 21 now, or if you are the derivative beneficiary, the person who was youngster or a teenager when the papers were filed, and now you find yourself in your mid or late 20s, definitely talk to a good immigration lawyer who has experience with the CSPA program. We have helped many, many clients with this program and brought smiles to many people who thought that it was all over in terms of family unity and families getting the green card together. So I encourage you to call our office, bring all your documents, bring the proof of filing date, the proof of approval date. We will do the subtraction with you and help figure out if your children who are now over 21 would be eligible under CSPA to be included in your case. Thank you very much.